In this screencast, we're going to look at the third aspect of contract law, which is to do with vitiating factors. Now, these are methods that a party can use to try and get out of their contractual obligations if there is some form of defect in the formation of that contract itself. And I think it's really important to note at this stage that this process is quite distinct and separate from terms being things that are incorporated into the contract and where one side or the other doesn't perform their contractual obligations as terms. There's some form of remedy for breach. Now that aspect, though, is we're going to look at under the discharge, the fourth section, the fourth screencast. This part is where there is some form of defect. Now, from a practical consideration, if you were to bring an action in the courts and there was some ambiguity or argument as to whether or not particular representations are actually terms or not, it's not at all uncommon for parties going to courts for contractual law disputes to raise vitiating factors, sometimes multiple areas. And certainly some of the cases that we're going to look at in this recording, the parties in those situations often try to fire a shotgun approach over a wide area to try and get a good outcome for their client, rather than a sniper rifle where the particular parties in those cases are trying to achieve one particular outcome, either for breach or for vitiating factors. So it's not uncommon in situations for multiple actions to be taken. So here what we're going to do is to just go through each of the important key areas of vitiating factors, being misrepresentation, mistake, duress, undue influence, unconscionability, and illegality. Really, the main thing we're looking at when examining vitiating factors is this idea that a contract somehow has some form of defect as a result of a lack of real and genuine true consent between the parties. Now, from a perspective of terms and breach, the contract can, at least on the surface, appear to be fully formed, but there's something fundamentally flawed or wrong about it. And while courts, as we've mentioned in earlier screencasts, are really reluctant to pull contracts apart, what they can do instead, though, is to use a separate set of rules and a separate sort of cause of action that people can go to courts to try and claim to obtain some sort of relief or remedy where a contract's been entered into without this genuine consent. The first area we're going to look at is misrepresentation. And this is really probably the easiest one to grasp conceptually. It's where somebody makes a representation to another person to get them into a contract. And that representation, remember, can't actually be a term. If it is a term and it turns out to be false, then what that person promised they haven't managed to fulfill, and as a result there is an automatic right that arises to sue for breach of contract. So with a misrepresentation, it is a statement that is made that is not a term. Now, from a very pragmatic, practical perspective, if you're going to trot off to court and there is some ambiguity as to whether a statement is a term or isn't a term, usually you argue both. The preference in 99% of the cases for the plaintiff is for something to be deemed to be a term, because then you're going to get some remedy for breach. If you don't manage to succeed in that, though, you may still be able to succeed in arguing that something is a misrepresentation. Now, not all statements that people make to try and get others into a contract are going to be an actual misrepresentation capable of some form of remedy from the courts. Sometimes things might be puff, not intended by any reasonable person to have any form of legal effect. And the representations that aren't puff can't be collateral contracts. In other words, they can't be capable of being independently inducing someone to a contract and having that inducement form the basis of a separate contract. A misrepresentation has to be a statement of fact, of actual fact, not future intent, not opinion. It has to be actually targeted to or addressed by that party to the other, that is both designed to get them into the contract and actually was material in doing so. What makes a statement of fact? Well, fundamentally, a statement of fact is importantly different and distinct from a mere opinion about something. A mere statement of opinion is not going to be a misrepresentation. However, in some situations, it will be. Those situations are times where the particular opinion is either not actually held by the person making that statement, or it's based or grounded in facts that that person really knows to be false, or it's a statement of something that person's going to do where they really had no underlying intention to take that particular set of steps. And so, starting with Bissett and Wilkinson, there was a contract for the sale of 2 packets of farmland, and the purchaser asked the seller, "Hey, do you reckon we can get 2,000 sheep to be run on this land?" And the seller said, "Look, I've never actually run sheep on this land, but I reckon you could probably get 2,000 on there." And there the court said, "Look, that is a mere statement of opinion. The person had not actually run sheep on there, didn't make that representation with any claim or expertise that particular state of affairs would be. It was just a mere opinion. In that situation, that was not held to be a misrepresentation. Whereas a different situation in ESSA Petroleum and Martin, where the sellers of a petrol station knew a series of facts to do with the road being rezoned. And so there, when doing the estimation of the number of gallons per year that this petrol station was likely to come in, they knew darn well that that was going to change when the road got rezoned and it would bypass this petrol station. One of the difficulties that flows from this is this idea of intent is very difficult to prove at law. And this is a recurring thing that you'll have throughout these screencasts. Intent is very hard to prove. You can't just chop people's heads open, look inside, and see what they were actually thinking at that particular point in time. And so in the case of ESSA Petroleum, you had to look at surrounding circumstances and look at memos that existed and the facts that were used in the process of negotiating. Similarly, in Edgington and Fitzmaurice, that was to do with the prospectus that was issued. And in it, the directors stated explicitly that money for debentures that they were issuing would go into buildings, vans, horses, and expanding their business into supplying fish as well. But fundamentally, the actual purpose was to pay off existing debts. And there, the sort of stated intent of the party was clearly at cross purposes with the underlying reality of what they actually intended to do. And in that situation, that was held to be a misrepresentation. But also make note here that if you genuinely do hold a future intent to do something, but that particular set of circumstances doesn't come about, it's not going to be a misrepresentation, provided that you did actually hold that intent at the time of formation. Another thing to note with a misrepresentation, it has to actually be material in inducing the other party into the contract. Now, clearly, if there's a situation where the other side never knew about the particular statement that you're issuing that turned out to be false, then they can't turn around and argue that it was false and therefore they were lied to, therefore they should get some sort of remedy. No, you never knew about the particular misrepresentation, therefore it can't have legal effect. And I guess the flip side of that is that even if you do know about it, but you know that it is false, then you can't turn around and argue it was a misrepresentation. If you go into it with your eyes open, you're not going to get a remedy from the court. And Holmes and Jones was to do with cattle numbers, this for the sale of a station, and the purchaser knew the numbers were wrong. And as a result, they can't turn around and argue that it was, if they knew that it was wrong, that it somehow induced them into the contract, and it is not a misrepresentation as a result. Similarly, the actual statement that's being issued to them has to actually be relied upon. If a statement is made to you, but it's kind of irrelevant in terms of your decision making, then you can't turn around and argue that consent to enter the transaction was somehow invalid. You have to rely on the statement. Now, it doesn't have to be the only reason that you entered into a contract. So if there are 10 reasons, a misrepresentation might be one. And look, if it is only a small aspect of the reason you enter into the contract, you're actually going to have a harder time trying to prove misrepresentation. You as the plaintiff must prove that the misrepresentation was material in your decision. It was actually a reasonably substantial reason for you to enter into the contract in itself. And also, as a side note, a statement that's made after you enter into the contract clearly can't be a misrepresentation. Why? Because it kind of induced you to form the contract if the contract's already formed. Silence, that is the act of not saying anything or not making a representation, at common law anyway, doesn't usually cause a misrepresentation to arise. You not telling the purchaser of something that you're selling about particular aspects of it or defects, usually negative things, doesn't necessarily give them a right to seek some remedy for misrepresentation at common law. And the case there, that Keats and the Earl of Cardigan, is where there the Earl rented out a house to the plaintiff knowing they really wanted it to move straight in, and didn't mention that the house was actually uninhabitable. There, though, the court said, look, mere silence on its own at common law is not a false statement. It's not going to give you that right to rescind that contract. And certainly for the sale of goods, this is the extension of this old concept of caveat emptor, buyer beware. When you enter into a contract as the purchaser, ask questions, investigate the thing that you're buying, look at it, examine it. You have the onus to go and make all of the inquiries. The other side's not obliged at common law to reveal all of the defects of the thing that they are selling. But like a lot of areas of contract law, there are going to be exceptions to that rule. And the first is to do with what we call half-truths. Now, in Dimmock and Hallett, there was a situation where the purchaser of land asked if these packets of land had tenants, and the seller replied, yes. Why was this a half-truth? Well, the tenants had all given notice to leave. So the tenancies were about to come to an end. So this is one of those situations where there's a bit of leeway. Again, there is this idea that it's up to the purchaser to be vigilant and diligent in going about examining the property and asking the questions. And again, this is a strict common law approach. Carefully phrased answers are different and distinct from, I guess, being dishonest in terms of how you go about phrasing things. And the courts really look at what, again, using an objective test in this, what would a reasonable person think in response to a question? Would this look like a real and genuine bending of the underlying truth? I mean, in that situation, again, the onus is still on the purchaser to go and make investigations. But when asking questions that are phrased and structured in normally a clear and understandable way, again, a carefully worded answer that doesn't reveal the underlying truth of the situation is not going to be sufficient to fall under the silence rule and can still amount to a misrepresentation. Similarly, where you make a statement usually as part of contractual negotiations, and that statement, while true at the time, becomes false at some stage later, again prior to the point in time where a contract's formed, then you do have, I guess, a duty to disclose material changes there. It will be a misrepresentation if what you have said becomes false at a later stage. And so there with Flanagan, as part of the sale of a business, Dr. O'Flanagan said quite honestly and truthfully in January that his medical practice had £2,000 a year income takings, but later on he got ill, and so his takings went down to sort of £5 a week, so I mean much smaller than that. And the contract that was signed used that original statement as part of it. So in that situation, the court said, yeah, you really had a duty to disclose that underlying material change in facts to do with the representation you made that was going to be a misrepresentation and will give the purchaser some form of remedy. Also, there are particular classes of contracts, things for stuff where you have a duty to disclose everything. Insurance contracts are the classic situations. You have a duty of utmost face, of uberame fide, to disclose all material facts. And in those situations, silence is just not going to be accepted, and it will be a misrepresentation. Similarly, if you're in a fiduciary relationship, that is a relationship of trust and confidence, where you have a duty to disclose all material information to the other party, to the weaker party in that relationship. So directors to the company, employees to employers, and so on. So these are some general rules for misrepresentation in terms of being able to prove the underlying cause of action. We'll return to later to look at the remedies for misrepresentation. We'll do them for each of the vitiating factors at the end of this recording. Contractual mistake is a vitiating factor that arises where the parties, or sometimes one party, enters into a contract where there is some fundamental mistake involving the subject matter, which can either be a physical object or to do with the actual performance or the obligations of the parties to this contract. There are three types of mistake. The first we'll look at is common mistake. That's where both parties are mistaken about the same thing. Then we'll briefly look at mutual mistake, which is quite a rare set of circumstances where the parties are at cross purposes. And then finally we'll look at unilateral mistake, which by default gives no remedy. So a common mistake is where both parties are equally mistaken about something absolutely core or fundamental to the contract itself. And this can be either whether the particular object that they contract with is still in existence, or possibly it's been destroyed, whether or not there's a fundamental quality of the subject matter that both parties are mistaken about, or in some circumstances where both parties are equally mistaken about how their intentions were recorded in a document. I'm going to talk about the first two of these, and then we're going to look at recordings of intention and the remedies for that, but later on in the recording. So the key thing to note about common mistake is that the particular piece of subject matter has to have been fundamentally flawed or destroyed at or before the time of formation. All right, something very fundamental to the contract must have been extinguished in some way. So this could be, for example, a situation where both parties come together to perhaps buy or sell something large, a boat perhaps. And unbeknownst to both of them at the time of formation, that the boat had been completely destroyed or wrecked. And there, both parties are equally mistaken about something fundamental to the contract, being the existence of the subject matter. And it can't have been something that we actually discussed and talked about and encapsulated in the contract itself. Why? Because if we did, then it's going to be a term. Now, there can be a situation, though, where the existence of the subject matter isn't an express term that we've negotiated. It could be an implied term. In McRae and the Commonwealth Disposal Commission, this was to do with salvage of a vessel that had sunk off the coast of northeast Australia. Now, again, this was like many of these contract law cases. The parties took many arguments, trotted off to courts in terms of their seeking some form of remedy. And one of them that the Commonwealth tried to argue was that there was common mistake. Hey, we are both mistaken in this situation about the actual existence of this wreck, because when McRae got to the location, there was no boat. And that particular argument failed. And there the court said, no, the existence of the subject matter is an implied term in this particular contract. And if we recall the rules for implied term, it has something, the courts don't readily or regularly imply terms into contracts. It has to be something that, look, if we'd stopped to think about it, we would have incorporated into the contract. It has to be so obvious that it goes without saying. A contract for the recovery of a vessel is going to be based on the fact that the vessel actually exists. There is a bit of a curious rule here. If the subject matter, or the existence of the subject matter changes, in other words, if the subject is destroyed after formation, then common mistake isn't going to apply. Again, this goes back to this idea that the court does not quickly or readily destroy the underlying bargain. Now, there are other doctrines, the doctrines of impossibility and of frustration, which can operate as a mechanism in order to resolve this particular dispute. But it's not going to be common mistake. The actual mistake has to occur prior to formation. And it's certainly in Taylor and Caldwell, the hall that two parties had come together for one to perform in, the hall itself burnt down after formation. And there it wasn't common mistake in terms of the existence of the subject matter. It was going to be resolved under other doctrines of law, either frustration or, in that case, impossibility. Now, another thing to note, that while the existence of the subject matter is quite fundamental to many contracts for the purchase and sale of things, either real property or goods, the fact that a particular quality of the subject matter both parties are mistaken about might not cause common mistake to arise. So in Leaf and International Galleries, there a person bought a painting from a gallery that was painted by Constable. Now, John Constable is a well-known British artist, and so as a result, that particular painting would have a high deal of value, or at least it would have if it was painted by John Constable and not someone else whose name happened to be Constable. And there, of course, you can see the dilemma. The gallery and the purchaser were both mistaken, but there the court said, look, at the end of the day, you are mistaken, and you're mistaken about something that's pretty important in terms of the value of that particular painting, but it's not absolutely fundamental. That particular quality, sure, may reduce the value of it, but at the end of the day, you still got a painting, and that painting was painted by somebody called Constable. And in that situation, common mistake will not arise. I'm going to talk really briefly about mutual mistake now. Mutual mistake is very, very rare. The reason for that, you have a situation where the parties are not mistaken. Each of them are not mistaken about what the particular subject matter is. It's just that there are two subjects. And again, you think, what? How does this ever come up? Well, in Raffles and Wiltshire House, it was a contract between two parties to transport a load of cotton from a ship called the Peerless from India. And in that situation, turns out there were actually two ships with the exact same name, both called the Peerless, that were both taking cotton from India, one in June and one in October or November. And there the court said, look, this doesn't come up very often, but in that situation, you are both essentially working at cross purposes. Party A is not mistaken about what they thought they were contracting with, and Party B is not mistaken about what they thought they were contracting with. It's just that those two things were different. It's exceedingly rare. It doesn't come up much in commercial practice, but the result is essentially the same as common mistake. And again, we'll talk about the remedies for these later in the recording. Here we're looking at unilateral mistake. That is a situation which is vastly more common than the other two, where just one side of the contract, just one party, is mistaken. And if you think about this from your own experience, it is very common as an occurrence that you purchase something, get home and realize that it doesn't actually do what you thought it did. One, or in some situations both parties being mistaken about certain aspects of the contract, is just a phenomena in life where we don't have perfect information about things. And from the court's perspective, the default remedy for being mistaken about something relating to a contract is absolutely nothing. The old standing maxim of caveat emptor really just means let the buyer beware. When you buy something, be really careful about checking to make sure it does what you think it does. And as you can imagine, that's a pretty harsh sort of rule, but it has been the rule and it is the law and will remain so. Now, there are some situations, though, where to offset the underlying harshness of this rule, there are some exceptions that will arise either in equity or in common law, which I'll go through now. The first of these in Australia was enshrined and explained by the High Court in Taylor and Johnson, is where one side is mistaken about the contract and the other side has become aware of that mistake and in bad conscience actively seeks to make sure the other side doesn't find out about this mistake. And that in Taylor and Johnson, it was to do with the sale of land. Now, it was 10 acres of land, and the sale price was $15,000. The land was worth market value about $50,000, but there was a bit of proposed development supposed to come up in the area. And so it was possible after the rezoning that it might be worth shy under $200,000. What was the difficulty with this? Well, the seller thought that she was selling for $15,000 per acre. The buyer very much was aware that it was only $15,000 all up. Now, what the High Court in this situation did was examine the underlying things behind it. And again, they were happy to accept the evidence here and looked at, well, in this situation, surely at common law, well, it's too bad. At common law, you go and you look at the underlying contract, look to the terms. If there's no other defect, that's what the contract is. Here, though, they said that, look, this is a situation where, for unilateral mistake, equity will have to intervene. Because in that situation, the purchaser was both aware the other side was mistaken and in bad conscience took active steps to stop her from finding the true underlying facts of that particular contract. From a commercial perspective, it probably bears noting that trying to get some form of remedy under unilateral mistake where you're mistaken is a pretty high bar. You as the plaintiff have to prove all of these aspects, and it's an equitable remedy. So that means the courts are going to look at the underlying amounts of the consideration each side offers in that particular transactions. And so here the courts did, and were comfortable with the amounts, even though the position of the mistake, certainly if the contract stood as it was, the buyer was getting a great deal, whereas based on the $50,000 that the property was worth, that if it was to be sold for $150,000, then the seller, in theory, would have had a very good, a good deal there. So please take away from this that the courts don't grant this remedy lightly. They like to not be the destroyer of bargains, and that long-standing rule, let the buyer beware, is certainly an important aspect, and really the dominant rule in terms of unilaterally being mistaken about aspects of a contract. Now, there is another area which, to be honest, is a bit of a dog's breakfast, in that it is unclear, it has not been very well defined by courts over the years, and even in a relatively recent case, Shogun Finance, the British courts had the opportunity to really clarify this area of the law, and they unfortunately did not. And that's to do with being mistaken about the identity of the party that you are contracting with. Now, the reason why this is important is usually to do with property and whether it passes or not to third parties, and how the rules for that apply. Why this is important, almost all of the situations here involve something to do with what we call a rogue in contract law. Now, a rogue is a person who usually enters into a contract and then disappears. Now, the difficulty there, and why these things end up being in dispute, is often the property has been passed to a third party. And in earlier cases, such as Cundy and Lizzie, the situation was where one party specifically intended to deal with another party, and they were mistaken about the party that they absolutely intended to deal with, that the contract was void. What does that mean? It means there was no contract, and as a result, title never passes from the goods that are supplied. Again, most of these situations are where somebody's buying goods and then disposes of them by selling them to a third party here. And the distinction is important because if you purchase something from the rogue that's been sold to them by a contract that was void, in theory you can't get good title. There are some other rules, statutory rules, that kick in here, but the default position at common law, where a contract is void, is that title can't pass to these third parties later on. And so really the difficulty that these problems and these cases are trying to resolve is who's going to bear the loss here. Is it going to be the seller, or is it going to be the third party who's bought the goods that they may or may not have good title to? And unfortunately, it's really not clear. Certainly in Phillips and Brooks, the court said that no, actually, they went to sell jewelry in that case to ostensibly to a particular person, the contract was void, and the goods could be recovered from the third party. So essentially following Cundy and Lizzie. Lewis and Avery, quite a lot more recently, was decided in the opposite. And they said there the rogue in this situation purported to be Richard Green, who apparently was a famous actor a long time ago, who played Robin Hood. And they sold, the car was sold to the rogue, who then on-sold it to someone else. In that situation, the court, their Lord Denning, had said that no, in this situation the contract is voidable. What does that mean? It means that if you don't elect to void this contract, to rescind it before the title passes to a third party, you're too late. Your right to do so disappears. And more recently again, in Australia, in South Australia, in this kind of Papas and Bianca investments, the court went through and examined these cases, and they said, again, much more polite language, that yes, the law is really, really unclear here. From a common sense perspective, it seems that I guess Lewis and Avery is to be preferred, in terms of trying to work out who's going to bear the cost. And really this goes back to this idea that the law benefits those who are punctual and quick to uphold their rights rather than those that are tardy and take time. So that if you very, very quickly assert your right to rescind, grab the property back off the third party, or give some sort of notice, then that's your rights should be preferred, and the other side should bear the cost. However, in Shogun Finance, the British courts really, reverted back to that Kunze and Lindsay set of rulings that said, well, no, strictly speaking, things are going to be void. It's a common law test. It's not a maxim in equity. And so you've got this difficulty. How to resolve this? Well, I guess if situations come up like this in your own commercial practice, get on them really fast. If you find out that the party you're dealing with is not who you thought you were intending to deal with, then find the property and try to resolve it as quickly as you possibly can. Don't sit in your rights and think that the courts are going to do it for you. Now, duress is a different area of vitiating factors, and it's quite old, or at least one of the three types of duress has been around for quite a long time. This is an area of law that I guess the simpler, most basic form has been around for over 1,000 years, but the more sophisticated forms of duress have really only developed in the 20th century in regards to duress to goods, and only really since the 1970s in regards to duress to economic interests. And so again, you've got these three categories. Duress, as you might quite reasonably think, is this application of what we call illegitimate pressure in order to coerce people into contracts. And the most obvious of these is, of course, very direct threats to your person, your family, your friends, in order to enter into a contract. And as you can imagine, courts aren't too happy about people doing this. And again, for a long time, the common law has said, look, you can't threaten somebody to enter into a contract. That's ridiculous. And so the courts, again, for a long time, have given people the right to render a contract void. It is essentially they get the right to make it void. It is not void by default. And that's kind of in line with the idea that in some situations, a party might want to actually uphold their existing contractual rights if they receive some form of benefit from doing so. It's interpreted quite strictly. In Barton Armstrong, there was some death threats for a party to enter into a contract, and you've got to appreciate the courts, and they take these things pretty seriously. The downside is, of course, if you're actually receiving death threats, there may be some difficulty going through the court system anyway. And this aspect has been recognized in more recent times by the other two arms of this vitiating factor of duress. And the reason why duress to the goods was a relatively recent invention was the courts would think, well, if somebody is coercing you into a contract by threatening your goods, in theory, if they actually smash up your goods, you are going to have a right to sue in conversion or trespass to goods. And so, why would you ever be induced into a contract as a result? And so that was the reasoning the courts used for a long time. But in more recent times, courts have appreciated that's not how human beings work. Sometimes the threat to your particular goods, be it in the form of direct damage or conversion, can be overbearing. That it actually is the fundamental reason why your will is overborne and you end up being coerced into contracting. Now, the example here of Hawker Pacific and helicopter charters is it's a pretty good example of this. There, you had a helicopter painting business, and there were some guys who ran helicopter charters. So they sent their helicopters in to be painted, and they needed them back. They needed them back to actually run a charter, and the charter entity owed money to the painters. And the painter said, we are not going to release your helicopter unless you enter into a contract promising to pay X, Y, and Z, either relating to previous contracts and for the current ones now. They knew that the charterers needed the helicopters back. And so the courts there said that, look, that essentially this idea of withholding the goods and not releasing them is going to amount to duress, and again gives the innocent party here this right to render the contract void. Now, again, even more recently, is this idea of duress arising from threats to economic interests. And this, in most of the cases, occurs where there is a threat by parties, usually parties that have dealt with each other a few times and have got existing contractual relations, a threat by one party here to either cancel an existing contract or to not renew or to create new ones, or not continue ongoing contractual relationships. And this can be a little bit of a bit tricky in terms of the courts determining whether or not this is illegitimate or just hard bargaining on the behalf of parties. And these can be quite large entities here. So, for example, in North Ocean Shipping and Hyundai Construction, it was to do with the refurbishment of a large tanker. Now here, the guys doing the work on the boat were they'd had a fixed price stated in US dollars, and in the 1970s the US dollar got devalued, and so as a result the shipbuilding company Hyundai, they demanded more money as some form of compensation. Now there wasn't actually any entitlement in the contract, but the Hyundai guys said they're not going to carry on doing any work on this boat unless this particular increase is going to be granted. And so in this particular situation, North Ocean, they just got a really good charter. They needed the boat to be ready on time, so they just capitulated. They said, yeah, okay, sure, we'll go and do it. And they paid the money, and then afterwards went to court to argue, look, this was economic duress. And they won. Or at least they won the right to have this contract avoided. The difficulty here, and this is one of the, one of the considerations that you need to take into account with vitiating factors, is that for something like duress, sure, you get the right to have the contract avoided, but you're not going to get damages directly. Now here, importantly, yes, the court said, yes, this is economic duress. The difficulty they have, though, is that they took 9 months before they went to actually apply to get the thing set aside. And that was too late. It was too late. They had, by this stage, because they took no steps to have it set aside, in essence, they have just ratified or just affirmed the conduct of the other party. So just be mindful here that you have to be careful about sitting on your rights for too long when trying to apply to have contracts vitiated. Next vitiating factor to look at is one which is very much grounded in equity. It's called the doctrine of undue influence, and it arises where there is some form of either a relationship of trust and confidence, or where somebody's will is overborne, and as such they enter either into a contract or they provide some sort of gift to the stronger party as a result of either this domination or this relationship. And so when examining these, we can look at them as, two distinct areas. One where you have the relationship, or one where there is this general domination. So in terms of relationships, these really fall into two categories. There are what's called special or established categories of relationships. They are a fixed list. There aren't very many of them, but the courts, again, originally, as this is an area which flowed from equity, it was originally the chancery, which was run by priests. They came up with a list of special relationships in which, if you are the weaker party in this relationship, you automatically have undue influence presumed if you are contracting or gifting with the stronger party. And those are parent and child, guardian, ward, doctor, patient, solicitor, client, trustee, beneficiary, and religious advisor and disciple. Now, if you are the plaintiff, all you have to do is prove that you were the weaker party, and this, again, the child, the ward, the patient, client, beneficiary, and so on. And the other side was the stronger party, and that the particular either gift or contract occurred. By default, you are granted this remedy in equity. Now, again, there are some defenses to this we'll allude to later, but that is all you as the plaintiff have to prove. And that's an important thing when we think about this idea of the onus of proof and who has to go in proving things. That is all you have to do to tick that box. Then it's up to the other side to have to raise some form of defense to a particular action. So by default, you get these things set aside. Now, importantly, as a statutory rule, if you have a power of attorney, now that's a situation where a person who's usually got some form of impaired capacity has agreed to allow another person to act on their behalf in a host of situations. There is a statutory rule in Section 38 of the Powers of Attorney Act, 1998 Queensland, which says, look, it is presumed any transaction between the party who is the principal and their agent under this particular statutory regime, that undue influence will arise. So again, you only have to prove that this situation exists. You don't have to go any further with undue influence. It's up to the other side. And if they don't, for example, turn up to court at all, they can never prove that particular set of facts, and so you're always going to win. So what do we do if we are in a situation where we aren't in one of those half dozen or so special categories? Well, we can try to establish that the particular relationship that we have is one of trust and confidence. Now, this has to be done on a case-by-case basis. It's up to the plaintiff to prove. They bear the onus of proving this, that the specific relationship that they have. And the courts, again, are willing to do this in a variety of situations. And this kind of makes sense. There may be some situations where, for example, a very close friend or a caregiver can actually exert a lot of power over a person because they've been their confidant for a long time. It may also be important to note some of the types of relationships where it isn't going to be a special category. You have to prove it on the facts. Husband and wife and engaged people, by default, are not deemed to be in a special relationship in regards to undue influence. Although there is a particular quite quirky rule, the rule in Yerke and Jones, where a wife, and by wife I literally mean a female spouse, is entitled to have a contract set aside if their husband does something fraudulent on a transaction for the sale of land or some form of guarantee. It doesn't apply to husbands whose powerful wives can do the same sort of behaviour. It doesn't apply to gay couples. It's quite an odd rule, but it is still good law in Australia, and was again upheld in Garcia and the National Australia Bank in the late 90s. So I guess the key thing to note here is that once you have established this, if you can prove this to the court, that the particular relationship, which isn't one of these special categories, but it is one of such trust and confidence that undue influence ought to arrive, you as the plaintiff need to prove these things to the court. Once you've done that, it's a bit like with the special category, you've got to do these extra steps to prove that relationship exists. Once you've done that, the onus falls on the other party to try and raise some form of defense to the action. Now, another way that undue influence can arise is what we call actual undue influence. And again, this comes in two flavors. One is where you have what we call actual coercion, and that is a situation where there is some form of often temporary, illegitimate advantage that one party gets. And again, in most of the cases here involve some form of threat or veiled threat to often to do things, for example, like tip off the police about a family member who's done something naughty, or threatening to bring something to light to the authorities. And in those situations, the courts do accept that a person who otherwise you don't have any form of special relationship with, nonetheless your will is overborne, even if only temporarily, enough to enter into a particular contract. This final area of undue influence is what we call general domination. This is a situation where, look, it's not a one-off use of some illegitimate advantage, and it's not a relationship as such. It's the way they describe this is that there's some form of illegitimate control of another's mind. And this can arise, and most of the cases reflect this, where there is some form of spiritual guidance. These cases have this. So you haven't got a special relationship, often because the person's either not in a particular religion and they're not a disciple of this particular religion, so that part's not satisfied, and you haven't satisfied or can't satisfy that it's a special relationship of trust and confidence, which you can still argue under undue influence that this general domination applies. And it's the sort of thing that can pop up, unfortunately, when people are very, very sick and they employ some form of spiritual healer or guiders or faith healers. And it can be difficult in those situations to prove that the contract or gift, is often the case, falls under any other area. And so the courts have developed this, I guess, catch-all situation where one party can prove that this domination exists and apply an equity to have achieve some form of remedy, which often have a contract set aside. The next area of vitiating factor is known as unconscionable dealings, and this is actually phrased in different ways in different locations and by different judges. In some texts we use this slightly simpler term, unconscionability. I'm not convinced that's actually a word, but if it is, then it represents the exact same thing as what we're talking about here. And really, this is the contemporary mechanism that courts in Australia use to resolve things that require equity, to resolve defects in the common law, this unconscionability doctrine. So the starting point with unconscionable dealings is that the common law is really, really harsh. And certainly Justice Menzies in South Australian Railways and Egan was reading this contract and said, this is the harshest contract I've ever seen in my life. You, in dealing with the railways, have no rights or remedies whatsoever. You are not going to be able to recover anything under this contract, and by default, the courts don't really care. By default, the courts of common law don't provide mechanisms for contracts that are harsh or unfair or onerous, other than things we've discussed earlier in terms of terms, notice, for example. Parliament, however, has stepped in to do such things, and when at some stage later we discuss the statutory mechanisms for things, you'll see how they've resolved some of this harshness. But for a long time, equity has been able to intervene where there is some sort of defect in order to construct some form of fairer remedy for things. And the specific language that they use is to do with special disadvantage. Contracts themselves can be perfectly well formed, but when entering into them, if one party knows of a particular special disadvantage that the other party has and actively takes steps to exploit that disadvantage in situations and circumstances that people would consider to be in bad conscience, then equity can intervene and the courts can grant some form of remedy to that disadvantaged party. Now, this vitiating factor was mapped out in the Amadio case. There, the agent from the bank arrived at the house where the son was seeking a loan, and he had two elderly Italian parents. And the parents, by all means, and the courts accepted this, thought that the son's business, in which he had owned all of these cars and did all of these things and he dressed all these nice clothes, they thought his business was very healthy and very successful. And so the son asked the parents for a guarantee across the business while the bank manager was there. He visited them at their house, and it became very clear from the facts that the parents didn't really speak English at all. And so they signed the guarantee, and sure enough, the son's business went broke, and the commercial bank went to try and take possession of the Amadio's house. And the High Court said, look, no. In this situation, this particular set of circumstances, the Amadios were at a special disadvantage. It was clear that they were both unable to really fully grasp the underlying nature and relative buoyancy of their son's business, and they didn't speak English. So in that situation, the bank being aware of these situations, they benefited from this, and they did so in unconscionable circumstances, situations that were against bad conscience, and there the Amadios were able to seek remedy against the bank. So what counts as a special disability? Well, the courts quite deliberately have not given a very exhaustive list. They've left this open-ended because this is the main mechanism that the courts use in Australia to grant some form of remedy in contract law in situations where the circumstances may be unjust. Now, there have been cases where those items listed on the slides, poverty, sickness, age, sex, physical health, mental health, drunkenness, infatuation, illiteracy, lack of education, lack of assistance, where necessary, have been found to be deemed special disadvantages. So in Blomley and Ryan, for example, there was an elderly but still quite solid farmer who'd been wanting to get rid of his land, but not really that much for a decent period of time. He had a reputation, though, of being a long-standing, famous in the community for being an alcoholic. And so a couple of the nearby farmers interested in purchasing his land arrived to talk about it. They brought the papers with them and 2 bottles of rum. And so there, the High Court said that, look, you guys knew about this disadvantage that he had. You actively sought to exploit it. We will grant some form of remedy here. Louth and Duprose is an interesting case involving a kind of dislikable guy who happened to be a solicitor, of course, who was infatuated with a woman. And the circumstances were that he didn't have a huge amount of money. It was reasonably modest sort of means. He organised to purchase the house that she was living in and convey it to her. Now, she really just wasn't into him. And importantly, the court noted that she would engineer situations of crisis. So much so that he felt some form of felt sort of compelled to help her in some way. And the High Court there said that, look, we recognise in the situation that he was really into her. She was very much aware of this, and she took active steps to exploit that to her advantage. And in that situation, the court said, yes, actually, we will grant some form of remedy to account for this. And it may be worth noting at this particular point that bargaining power, or the lack of bargaining power that a person has in a contract, is not a special disadvantage within the meaning of unconscionability. And the case for that is the ACCC in Barbatus Holdings. When we're looking at defences to undue influence and to unconscionable dealings, they're kind of similar in terms of the underlying structure. And the reason for that is that these actions are both born in equity. Now, there are also some statutory mechanisms. Again, we'll refer to that in a few weeks' time. But in the common law set of rules that flow from equity, where undue influence or unconscionable dealings has been established by the plaintiff, and again, there's a variety of ways that can happen, special relationship, actual undue influence, general domination, or where you've proved that you had a special disadvantage and the other side's actively taking steps to exploit that, you as the defendant can still try to prove that what you have done was actually right. It was actually fair. And the courts, when really trying to list out and explaining this defense to these actions, has said, look, really the key parts are that you need to prove that the transaction is actually fair. This remedy for UI and UD are both in equity. And so the courts look at the adequacy of consideration. They look to what a reasonable third party might have done. If this transaction was arm's length, would the numbers be about right? They take care to analyze these things. And a key step is the idea of getting third parties to look over the contract and give independent advice from both the financial aspects and the legal aspects of a particular transaction. Now, importantly, you have to lead the horse to water, but you don't have to make them drink. What does that mean? It means that you have to urge, you as the defendant have to urge the other side to seek independent third-party legal advice. And you need to be able to prove that. And in situations, for example, booking the appointment, driving the other person to the solicitor, leaving them there to do things in their advice has been found to be sufficient in some circumstances. In other cases, it hasn't. It really is a matter of question and degree in the particular sets of circumstances. One thing you will note, though, for those listening to this screencast who have purchased real estate, you'll note when dealing with any form of banking instruments, mortgages and loans and such like, there are a lot of big stickers with red tape that you can only pull off if you agree that you have sought third-party independent financial advice. And at all stages in the process, the agents of the bank will do so. And the reason for that flows largely from the Amadio decision. The final area we're going to look at is to do with illegality. Now, strictly speaking, illegality isn't a vitiating factor because it's not so much about consent. It's really to do with the underlying legality of either the contract as a whole or specific parts of it. Now, there's a little bit more to it in analyzing illegality than classifying a contract as being strictly unlawful and strictly lawful. And again, I think common sense and our own experience bears that out. There will be, from time to time, contracts that involve either the performance of two parties, in some situations becoming illegal or unlawful, and also from time to time there are contracts as formed that can have difficulties in that formation in terms of the underlying legality. And as we're aware, it's an element. When we're looking at the 7 elements of a contract, that lawfulness is a key requirement. And so that starting point is that, look, if a contract is illegal in terms of the underlying formation of it, then essentially there is no contract. And that idea of having or doing something that's illegal is not going to be enforced through the court system. Now, broadly speaking, there is statutory illegality, so things that are prohibited by statute as a result of the will or expression of the will of Parliament. And then you have common law illegality. So here we're talking about things that are prohibited in some way by statute. And this can be overt. The statute can literally say contracts of a certain nature, of a certain time, or between certain parties are expressly prohibited. And that aspect is relatively straightforward. Where things get a little trickier is when a particular type of contract, or again particular parties to a contract, create a situation where, look, Parliament hasn't overtly said that this contract is going to be prohibited, but it can be implied, usually through the interpretation of that statute and looking at the underlying purpose of what it is. The case there of Pretorius and Muir involved the selling of some form of prescribed goods, medications, which was it was argued that it was impliedly prohibited under the then Therapeutic Goods and Cosmetics Act in New South Wales. Now, in that act, there were offences punishable by fines and imprisonment to sell certain goods unless you had a license under that act. And the judge in that case said that, look, even though it's not expressly prohibited, right, the entire purpose of this piece of legislation is to try and protect the public. And part of that mechanism of protecting the public is to punish people and fine them for making these sorts of sales where you've got unlicensed persons selling drugs in the situation. And so as a result, the whole purpose of this is to protect the public, and so therefore this style or type of contract is going to be illegal. However, the courts, as a general rule, don't like making contracts unenforceable. And again, it goes back to this very long-standing theme that the courts will bend over backwards to uphold and maintain a contract or a bargain between parties. And when they're interpreting the underlying purpose of a statute to see whether there's some sort of implied prohibition, they're going to examine the people, the classes of people that particular statute is designed to protect. In the case of Yango Pastoral and First Chicago, there was some breaches of the banking licenses. So First Chicago was operating in Australia, and they were issuing loans and taking deposits, but they didn't have a banking license. And so there the courts had to look at it and think, well, if we strike this out as being impliedly unlawful and prohibited through the statute, then you've got the people that the statute was designed to protect, the depositors of this particular bank, they're not going to be able to claim their money back. And so clearly the underlying purpose of the act was to protect the public. And so in that situation, they won't find that something is impliedly prohibited as a result. Now, the Australian High Court in Fitzgerald and F.J. Leonard have mapped out how contracts can fall under this statutory regime of statutory illegality. And that's where it's either doing something that's either expressly or impliedly prohibited, or it might be of a kind, type, or class of contract which is expressly or impliedly prohibited. The contract can also have been made to actually affect in its substance an unlawful purpose, or the contract could only have been performed in an unlawful way. Now, the High Court considered this in Fitzgerald and F.J. Lionheart, and there it was involved the creation and drilling of bores on a property in the Northern Territory. Now, the NT government had a statute, the Water Act of 92, which made an offence to construct a bore unless there was some form of permit. And unknown to the guys coming and putting the bores in, the other guys hadn't bothered to get those permits. And when there was dispute over payment, they argued, the contract's unenforceable because there's no permit. And there they failed. And the courts, again, looked at the underlying purpose of what that particular piece of legislation was, but they also noted that in this particular set of circumstances, the contract's not going to be unenforceable because the underlying intent of the parties was for it to not be performed in an unlawful way. And so this intent aspect is important in terms of contracts that, I guess on the face of it, are lawful, but are to be performed in an unlawful way. The courts do examine the underlying intention of the parties to the contract in terms of how they'll go about doing this. It's also important to note that incidental illegality through performance is not going to be enough to strike a contract down. And so that example of St. John Shipping and Joseph Rank, that involved a charter to carry grain from the US to Britain, and it was overloaded. And so the load line, the little Plimsoll line on the side of the boat, was submerged, and that contravened certain merchant shipping legislation. And there the court said, no, look, the overloading was not intended or foreseen or even an absolutely necessary means of performing this particular contract. It was inadvertent and incidental. As such, we'll draw this distinction here, again, because none of the parties' intents was for this to occur, and we're not going to render this contract unenforceable through the doctrine of illegality. Now, as well as having this doctrine of statutory illegality, the courts for a long time have had their own series of rules that really applied to contracts or classes of contracts that were going to be unenforceable at the courts of common law on the grounds of some form of public policy. Now, there's a list of the types and classes of contracts, but you'll note that as well as the very overt one, things, contracts to commit crimes or fraud, or defrauding the tax office and such like, there are also things that are a little bit broader in application. So contracts that may not be apparently unlawful on the surface. For example, those to promote sexual immorality. But the courts nonetheless have been known to follow their own common law doctrines to not enforce contracts of these types or classes or nature. So the very obvious ones, and also discussed under the legality aspect of being an element of a contract, is that contracts at common law that involve the commissioning of a crime or a tort or some form of fraud are not going to be able to be enforced in the courts. And again, Everett and Williams, this possibly fictional case that involved two highwaymen that ran around robbing carriages and then tried to conceal this fact, went to the courts to try and resolve the dispute, and the judge worked this out and then had them both hanged and the lawyer sent off to the colonies, transported. And it sounds a little silly as I explain that, but more contemporary cases can come up where people have been overtly unlawful. For example, North and Mara developments involved takeover. Now, in order to run the takeover, the share price of the plaintiff had to rise, so they asked their brokers which was North here, to buy quantities of their shares, and so they organised this, and then subsequently refused to pay their fees, and so the company that had organised to broker it by buying all the quantities of the shares went to the courts to ask for some form of compensation, and they failed, because there you've got an overtly unlawful act, and the courts are just not going to go anywhere near it. So there is the situation where something that is overtly unlawful, the courts of common law are just not going to touch. And it's important too, because often parties can't seek some form of restitution where a contract is going to be unlawful. The courts will generally not grant relief. The loss will fall as it lies for these strictly wholly unlawful types of contracts. Now, this idea of the courts being some form of custodian of public morality is a pretty old school doctrine, and this idea that the courts up until probably about the 20th century would refuse to uphold otherwise lawfully formed contracts that were to promote some form of sexual immorality did reflect the community standards of the time. So here we've got this Upville and Wright in, what was the year? The year 1911. And there was a lease for a residential property where the person overtly stated that it was to be used as a brothel. And the courts wouldn't uphold the contract there. They refused to hear it on, again, this grounds of sexual immorality. Whereas a more contemporary case, Burrick and Farnell, there the court said, and this was by the 90s at this stage, and they said that no, and again this was to do with the paying of work cover, also involving a brothel, and they said no, the times have changed, and this idea of the courts being unable to hear matters where there may be some form of immorality or impropriety is quite a different set of standards to what it was 100 years ago, and there they've got no problem upholding those. So as a general rule, most commercial arrangements are going to have a very hard time invoking this rule. Contracts to withhold the prosecution of offences or somehow impinge upon the administration of justice are going to be illegal at common law, though. So that, again, having a contract to do something or not do something, and as consideration offering to dob someone into the police, is simply not going to be lawful. Also, contracts that are going to impact the foreign relations of Australia or their allies aren't upheld by the courts either. Neither are contracts to defraud the Inland Revenue. And this could be either the state departments of revenue or the local council in terms of their revenue, or the federal Australian Tax Office. Now, the courts do make a distinction, though, between contracts that are simply unlawful as formed and those that are void or unenforceable. Now, so you can have situations where contracts can be fully lawful as formed, merely unenforceable at the courts. There's a distinction, and again, we'll go through this through the remedies component later on, where this plays out in terms of how restitution sits. But it more often arises where there are particular components of a contract are going to be not enforced by the courts. And you may recall from earlier recordings, there were types of clauses. For example, onerous clauses can't be enforced without a really strong amount of notice to the other party. The contract stays afoot, and the clause is still lawful, it's still legal, it just won't be enforced. At least in contract law, but other areas of law can be used in order to seek some sort of restitution. The classic case, by the way, of cases or classes of contracts that the courts have just refused to enforce, not because they're strictly illegal, but they're just unenforceable, is to do with gambling. Sometimes this is set out by statute. In the case of Defina and Kenny, this was the Gambling or Gaming Act in Queensland. And there they just said that, look, contracts for wages that people make in wagering contracts are going to just be void. No one can sue for them. And so there, these guys went off to court, and the High Court said, no, look, it's just not going to be enforceable. You can have wages with other people, and the courts have got no problems with that. People can sit and play poker. They can have such things, but there's no mechanism of enforcement if the parties so elect to trot off to court to try and have these things sorted by a judicial officer. Now, in terms of specific types of clauses of contracts, we mentioned slightly earlier this distinction between honour clauses, where a clause is put into a contract saying, hey, look, the parties to this agreement agree that this is merely an arrangement of honour or principle between two peoples, not intended to have legal consequences. The courts are happy to have that, what they call honour clauses. What that means is that it's not a contract. Whereas a clause in a contract that says, oh, if you don't like this, you can't go to the courts, is just null and void. You can't have a clause in a contract that makes it unenforceable in the courts. It can't be a contract because you'd have to go to the courts in order to enforce that particular clause. It doesn't make logical sense. However, you can include in a contract what they call a Scott and Avery clause, which is to require the parties prior to going to court to try and resolve their dispute using some third-party mechanism. So the classic case is arbitration. You are allowed to include a carefully worded clause in a contract that both sides are agreeable to for a third party to arbitrate a dispute before it goes to court. There, you're not ousting the jurisdiction of the courts, you're just deferring it, and those are fine. Now, there is a particular class of contractual clauses that we need to examine in a bit more depth, and these are quite common in commercial practice, and they're known as restraint of trade clauses. This is a class or category of contractual clause preventing one or both parties from operating or working in particular areas, industries, or geographic locations for a specific length of time. The starting point with restraint of trade clauses is that they, while they're acceptable, they have to be reasonable, both for the interests of the parties concerned and also in the interests of the public. And again, this two-step test, which was developed in Adamson, a case involving the New South Wales draft and the inability for players to go and move between clubs. And there the court said those seeking to want the restraining clause to be in place have to prove that it is in the best interest of the two parties, and then assuming that they do succeed in that, then the other parties seeking to, I guess, escape from the restraint of trade clause have to argue that that is in the interests of the public. They bear that onus. And it's important to note here that when examining whether it's reasonable either for the two parties, the two individuals, or and then looking again at the industry, you've got to look at the scope and scale and size of the industry. So in Warner Brothers and Nelson, that Nelson's actually the actress Bette Davis, and their Warner Brothers went to impose a 6-year term whereby she couldn't go and work for other movie studios. And there she moved to England and wanted obviously to work still in movies, and the courts were actually happy in that situation, saying, no, that actually seems reasonably fine and reasonable. It doesn't stop you from working in other areas. You can still do other promotional type things, but you can't work in movies specifically. Courts won't uphold these if it requires a person to not work at all. That's clearly not reasonable. But it can preclude a person from working in a particular profession in a particular area. And then Nordenfeld and Maxim Nordenfeld Guns and Ammunition, they're a 25-year restraint of trade clause for selling of guns and ammunition was found to be reasonable. Why? Well, because there aren't very many players in this industry, and as a result, only really governments buy guns in that size and that scale, and as such, that this, even though it seems like a very long time and very harsh, is actually quite reasonable in this particular set of circumstances. All right, so the next thing we're going to look at are remedies. Now, unfortunately, with remedies for vitiating factors, particularly to do with this idea of making things voidable or rescinding the contract, there's a little bit of disclarity and confusion in this area, and unfortunately this has been propagated by judges over the years. And really the reason for this confusion flows from the fact that in the olden days you would have undue influence and unconscionable dealings. These were remedies you would try and seek in the course of chancery. They were equitable maxims, whereas mistake and duress are common law actions. And misrepresentation, kind of unhelpfully, could be pleaded in either or. And so it's important to note here that particularly again with seeking damages, that wasn't something that equity could step in and do historically. You had to go through the courts of common law to seek damages under the tort of deceit or negligence and so on. And so it's important to note from the outset here that the common law rules and the equitable rules, particularly again with rescinding a contract or making it void, electing to rescind a contract, are quite similar, but not precisely similar. And that sort of flows from the fact that they came from two different, distinct areas of law which have been merged uncomfortably for quite a long time. And so perhaps the murkiest of these is this right to rescind a contract. Now, in misrepresentation, you always get a right to rescind the contract. However, that right to rescind in misrepresentation and in other areas can be lost. And again, the ways that it can be lost came from equity and have been adapted by the common law courts to apply to other occasions where a person gets a right to rescind or undo a contract. And in broad brushstrokes, these what we call bars to rescission, these where you lose your right to undo the contract, will arise if you take too long to run about and undo the contract. If you ratify it through your own conduct to affirm the wrongfulness of this contract and just carry on doing or going along with it. You lose the right to rescind if restitution is impossible. In other words, usually if money has flowed away from the parties and each is not in a situation to pay restitution to the other. And importantly, particularly with the sale of goods, you lose the right to rescind your contract if a third party is going to be impacted. And that usually arises in situations where the goods that have been unsold, and they've been unsold to a third party, somebody not involved in this contract, who, if you rescinded your right and took the goods back, they're going to suffer in some way. And equity has never liked impinging upon the rights of third parties, and the common law rights to rescind have started to really follow along and follow this same systematic series of rules for rescission. Now, in misrepresentation, when you argue misrepresentation, you've got to do it. You can argue all three, but you will only succeed in achieving misrepresentation under three different categories: fraudulent, negligent, and innocent misrepresentation. Now, if when you are proving that particular statement, and again, remember the elements of misrepresentation are only that you need to prove that the statement was addressed to you, it was designed to induce you into the contract, actually did so, and was false, and was a statement of fact. If you prove those things, that's fine. But if the other side actively sought to deceive you, or they were completely reckless or indifferent to the truth of what they were saying, then, as well as getting this right to rescind at common law, you also can seek damages at common law under what's called the tort of deceit. Intent at law is really hard to prove, and for a long time there were only two aspects to misrepresentation. You can either prove fraudulent misrepresentation and get damages under the tort of deceit, or you only got the right to rescind in equity under innocent misrepresentation. In the 20th century, the courts sort of filled in this gap, and this idea of negligent misstatement, where a party has a duty of care to make sure what they're telling you is true, and that the appropriate standard of care they've fallen below, and as a result you've relied on their statement and suffered some harm. That gives you, as the innocent party, a right to rescind, still in equity, as you would for innocent misrepresentation, but also the right to seek damages in tort, and in this case the tort of negligence. And there's some important distinctions between how damages being a sum of money awarded by a court, how these are calculated, and the things that can be included in them. And it's really important to note that damages for the tort of negligence, and indeed for breach of contract, as we'll go over in a subsequent recording, are limited by this idea of reasonable foreseeability, in that when you are trying to recover money either for a breach of contract or under negligence, things that were never reasonably foreseeable by the parties, that just happened through strange set of circumstances, are not usually a negligence. A person's, even where they've issued the statement, they're not going to usually have to pay or compensate the other party for. This is not the case with fraudulent misrepresentation. And there, the courts have said, no, if the plaintiff can actually prove that you intended to mislead them, or you were completely reckless in your disregard for the truth, you cannot turn around and argue, oh, we didn't foresee that particular outcome would happen. Too bad. You can be held liable for these often larger sum of damages that flow as a result of you fibbing to the other side. Now, another aspect of negligence, and this tort of negligence forming part of the damage award, is that statute has modified this to account for what we call contributory negligence. And that's in a situation where, sure, somebody has a duty of care not to mislead you in some way. They've fallen below that standard. You've suffered some form of harm. As a result, sure, they can pay you some form of compensation for doing that under this tort of negligence. But if you, as the innocent party, were also slightly negligent yourself, you didn't go through and carefully check the truthness of what they had represented to you, your damage awards can be reduced, and they can actually be reduced by up to 100%, effectively defeating your claim. And finally, it's important to note that for innocent misrepresentation, that is when some party has made a statement to you to induce you into the contract, it was false, and it was material, and it actually induced you, but they didn't mean to. And the court accepts that this happens from time to time. People can make quite innocent mistakes. And in that situation, you only get a right to rescind in equity. And you'll lose that right if you don't use it very quickly. And there, in that situation, you can't get damages from the other side if their misrepresentation was actually innocent. Where a mistake occurs, the parties can achieve some form of remedy. Now, the default rule is, though, for common mistake and mutual mistake, is that fundamentally there was no contract. So if there is no contract because of this fundamental defect in it, the parties can seek restitution from each other, but only under other areas of law. You can't do it in contract law. Again, equity can intervene where there's been some form of injustice, where parties have performed work, and title can't pass in situations where common mistake and mutual mistake apply. Now, I guess a difficult area of law is common mistake that isn't fundamental. And the reason for that is that Lord Denning, in the case of Solly and Butcher, made a decision where he said, look, in some situations where both parties are mistaken about something really important, but not so fundamental for common mistake at common law to apply, equity can intervene to prevent an injustice. And that was approved in the Australian courts in Savanisio and McNamara. However, it's really problematic where it sits at the moment in Australia. And the reason for that is that the English courts in Great Peace Shipping re-examined Solly and Butcher and said, no, sorry, Lord Denning, you've actually made a mistake. You've made a category error. There either is common mistake and the contract is void, and parties, can still seek some form of restitution or use tort or use some other areas of law to get some compensation to undo the damage that's been caused, that either exists or it doesn't. There is no separate equitable doctrine of common mistake. And that Great Peace Shipping case was followed in the case in Queensland of Australia Estates and Cairns City Council. However, that was a case that was heard in the Queensland Court of Appeal. It has not been heard in the Australian High Court. And so we're in this slightly awkward situation. Here in Queensland, at least, we are bound, if we take a matter into the Queensland courts, by the decision in Australia Estates. And that is at odds with the earlier decision in Svanisio and McNamara. So this is an awkward area of law. It seems likely, though, that if this were to flow up through the court system in Queensland or indeed elsewhere and went to the High Court, that if they reconsidered this, it almost certainly would be done in light of the Great Peace Shipping. But strictly speaking, that's not the law in Australia in all jurisdictions other than in Queensland. Okay, and just revisiting this idea of unilateral mistake, remember the default remedy for unilateral mistake is absolutely nothing. If, however, you are mistaken, there's a fundamental mistake about the contract by one party, and the other side, in bad conscience, actively takes steps to stop them finding out about it, this Taylor and Johnson exception, we call it, equity will grant you a remedy, and that remedy is the right to rescind or undo that contract. Similarly to how a party would do for innocent misrepresentation. Finally, I mentioned earlier about this idea of parties being mistaken about the recording of their intentions. Now, if there is absolutely overwhelming proof that the parties' intentions, both parties, has been incorrectly recorded in a contractual instrument, the courts do have, under their equitable jurisdiction, the ability to fix a contract. They do not do this lightly. The level of proof to get rectification, they call it, in equity, is very, very high. And because it's a remedy in equity, the other equitable maxims apply. Again, you can't take too long before going to the courts. They don't like doing it if third parties are going to be impacted. And this doctrine of clean hands applies. In other words, you can't be doing something naughty, to use a broad and simple term, in relation to the same transaction and expect the courts to give you some sort of justice in its equitable jurisdiction. Duress, as a vitiating factor, is a common law action. And as a result, the courts at common law have always given the parties this right to undo the contract at common law. Now, a distinction has to be made here that a common law right to undo a contract, they call them avoidable contracts, and some judges use that term, and the right to rescind in equity are very, very similar in terms of how they operate. However, it's a right to undo a contract for duress is, at least in theory, one that doesn't require the courts to intervene. You can essentially self-help by going and taking steps to undo the contract yourself without a court order. Anything under equity must go through the court system because equity is a discretionary set of remedies. It's up to the court's discretion in terms of whether they are granted or not. You can never rely on the court to automatically grant you that. Now, this may be essentially an illusory distinction because the remedy for duress, which is, again, the innocent party gets the right to either affirm the contract or to undo it. But if they're under duress, particularly for duress to the person, they may have grave difficulty in actually going and having some form of self-help, particularly if the other side's threatening to go through with particular nasty things to you. Undue influence and unconscionable dealings, and where the courts are applying these doctrines, usually give you the right to rescind. Again, to undo that contract in equity, and they're subject to the usual bars for delay, what we call latches in the equitable jurisdiction, and the clean hands doctrine as well. Certainly in Allcard and Skinner, the person who, again, was certainly found to be under the sway of a religious organization in that case, but they took many, many years before they were able to essentially come to their senses and then try to seek some form of restitution. And after that length of time and those many years, even though, sure, there was an injustice, yes, they would have been able to prove undue influence, but they took too long to bring the action, and as such were barred from being able to rescind that contract. With illegality, the default rule is that you can't get things back. Money that's paid or property that's been transferred is generally not recoverable by either sides. However, like a lot of areas of law, there are exceptions to this. And one of those flows from this case called Bonemakers and Barnett Industries. There was a hire purchase agreement carried on during the war. And this particular arrangement was in itself unlawful. But there they said that, look, you can actually seek to have your property returned to you. And the reason for that is that it was a hire purchase agreement. And so that the underlying ownership of this stuff never actually passed to the other side. And that you didn't have to rely on rights that were accrued or incurred through the contract in order to seek a remedy through the courts in that case. Another situation where you can claim a remedy is that when either you're nowhere near as much at fault as the other party is. If the contract, which may be either illegal as performed or illegal as formed, but if your amount of culpability is far, far less than the other side's, the courts are much more likely to entertain you being able to seek some form of compensation. Similarly, where there's statutory illegality, and the statute was designed to protect a particular class of persons or to give some form of benefit to a class of persons, and you're in that class, you're also much more likely to be able to go to the courts and ask them to intervene in order to give you some form of remedy or compensation. There is also a third category where a side can go and ask the courts to intervene, and that is the idea of repenting your sins. When you go to the courts, early in the process, put your hands up and say, hey, look, this wasn't originally going to be done unlawfully, but we don't want to do this unlawfully. We wish to stop at this particular point in time and try to undo what's been done. The courts can give weight to that when considering whether or not this particularly unlawful contract can actually give rise to rights for claims of compensation from either sides. Now again, courts don't like striking contracts down completely, and they will try to uphold them wherever where they possibly can. And in Nelson and Nelson, for example, there was a contract between family members, and fundamentally the purpose that it was trying to do was to defeat the Office of State and Revenue. There, though, the court said that, look, the actual underlying structure of this is still intact, and we are willing to entertain. If you go and repay the money to the state revenue, we will uphold the underlying structures of this contract in itself. And finally, I just need to note this distinction between illegal contracts and void contracts. So strictly illegal contracts, or those, again, that fall under these categories of illegality, the common law or statutory, don't usually give a rise for parties to go and get money back or to receive their property back. However, usually under a void contract, where there is no contract at all, then much like a situation, for example, where there's common mistake between the parties, if there is no contract, then title doesn't pass, and that money can be recovered from the other side as a result. And that's a distinction that the courts have made over a long time. This distinction between illegal and void contracts is one that impacts how the parties can go about seeking a remedy in the courts.